Good afternoon. Welcome to Cooperative Network's e-learning series of webinars. I'm Daniel Smith, President and CEO of Cooperative Network. Thank you for joining us today as we examine the requirements associated with holding an annual meeting virtually. Thank you also to our sponsors, CoBank and CHS. Well, how quickly the world changes. A year ago, this topic was not on our priority list. Today, it's on everyone's priority list. COVID-19 has placed it there, along with all the other changes the pandemic has brought to administration, governance, and communication within and between our cooperatives. We are fortunate to have with us today Morgan Helme of the Dorsey Whitney law firm in Minneapolis. Morgan works with Dave Swanson, who sends his regrets that he is unable to join us today due to a scheduling conflict. However, Morgan will inform us on ways to meet our legal obligation to our members to hold an annual meeting and to do so virtually. Morgan, thank you for joining us and welcome to Cooperative Network.
Thanks, Dan. I am happy to be here with you all today to talk about procedures for holding your annual meetings in these new interesting times we have. I'm an attorney with Dorsey & Whitney. We are based in Minneapolis, but we are a global law firm and we have offices around the country, and we work with cooperatives around the country and in all industries from agriculture to groceries, energy, healthcare, various purchasing co-ops, and beyond. I am also the vice chair of our food, beverage, and agricultural industry groups, and I work frequently with cooperatives on various corporate governance matters, fundraising, and general day-to-day contract matters. So today we will be focusing on the unique situation we're facing of how to host annual meetings in a pandemic, and particularly how to do so in compliance with law and in compliance with your cooperative's bylaws and articles of incorporation. Cooperatives are in a pretty unique scenario here in that they have this ingrained culture of annual meetings that you don't really see in other entity types. The best like analysis of other entities that are in a similar situation are public companies, but they have a history of holding combination virtual and in-person meetings with a lot of electronic voting. So it's different, whereas with a lot of co-ops, you might never have held a meeting virtually, you might never have voted electronically or by mail. And so you're really facing this situation for the first time. So I'm going to go ahead and share my screen here with a couple of slides that we have. And feel free to ask questions. I will try and keep an eye on the question box if anything comes in while we are talking. So these are the 3 points we're going to look at in more detail here today. The first is where you should be looking to determine if you can postpone or hold a remote owner meeting. The second is if you've looked through all of your controlling governance documents and laws and they still aren't clear about whether you can postpone your meeting or hold it remotely, or is there another way you can make an exception to your bylaws rules about your owner meeting? And finally, we're going to just walk through some best practices and tips and tricks we've been learning along the way for holding a remote owner meeting. All right. So first thing we want to look at to determine is what does the law and your controlling documents say about whether you can postpone or hold a remote owner meeting? And when we go through these various sources that you're going to need to analyze, we're going to be looking at them for a couple of different questions. The first is a remote meeting clearly allowed or prohibited? If voting will occur at your annual meeting, are you allowed to collect votes by mail or electronically? And the last consideration that I think a lot of people overlook and don't realize might be in their statute or bylaws is whether they specify that a meeting must be held at a certain time period or place, such as if it specifies that we have to hold our meeting in April, or we have to hold our meeting at the co-op's office itself. So the various resources that you're going to want to reference to make these determinations, these are listed in general by the order that they're going to control. So you're going to want to walk through them and review in this order. The first place you're going to want to start is with the statute that you are organized under. This varies. It could be a co-op statute, you could be under a general corporate statute, nonprofit, but whatever it is, that's your starting place. If you are organized under a co-op or nonprofit statute, there's also a chance that that statute is a little slimmer and incorporates by reference the terms of the general corporation statute. So if that's the case, you might have to be looking at two places to determine if the statute, how the statute handles annual meetings. These statute structures vary widely, but generally when it comes to annual meetings and remote meetings, they tend to take two forms. The first is that the statute will permit remote meetings for a co-op unless your governance documents specifically prohibit them. And the second form they might take is that they permit a remote meeting only if your governance documents expressly allow for them. So if you're in the first category, it's a little bit easier for you because you'll be able to have a remote meeting, and it would be pretty unusual for your bylaws to specifically prohibit a remote meeting. If it's the second, then you're stuck with turning to your articles and bylaws and seeing what they say about remote meetings. One other point here is that the state statutes might have specific rules for how you can hold a remote meeting. The most common of these, this is pretty consistent across the board, is that they're going to say you can hold a meeting electronically or remotely by any means where all participants can hear each other and can speak. So a teleconference line will work for that, a Zoom meeting, any of these will fit that form. So after you have looked at what your statutes tell you, your next point of reference, and you'll want to reference this regardless of what the statute says, because these are your controlling documents for your cooperatives. So you'll want to go then to your articles and your bylaws. Your articles of incorporation are probably not going to have any provisions relevant to you to this question because they tend to be very slim and mostly just address the matters that are required by law. Your bylaws are going to be your more comprehensive document here. What we have been finding is that a number of cooperative bylaws don't address remote meetings whatsoever because it has been so ingrained in the culture to hold in-person meetings, and we never really stopped to think that there might be a scenario where we had to have remote meetings. So if you're in those in that circumstance, you're not alone. We would advise you in the coming months to consider a bylaw amendment to change that, since we are learning lessons here that we did not know would be an issue. But there are many co-ops that do have bylaws that expressly address remote meetings. And if your bylaws do have provisions there, those are going to be controlling for you in conjunction with the statute, and you'll want to follow the rules that they have for holding a remote meeting. If your bylaws do not permit remote meetings, the next thing you're going to want to check them for is to see if they include a provision that allows the board to amend the bylaws. without a member vote. Normally, when this is included in bylaws, it is limited to cases of emergency or impossibility, which we would certainly have a reasonable argument that this is the case. And in that event, you would be able to have the board adopt a new bylaw provision that allows a remote meeting or changes your rules to allow you to postpone your meeting if that's the approach you want to take. The next place that might be relevant for you are board policies. And this is also something that you'll want to check your bylaws for. Your bylaws may give the board authority to supplement the bylaw procedures with policies that are adopted by the board. They might specifically say that the board only has authority to adopt a policy that is not specifically addressed in the bylaw, so you can supplement but not change the bylaws provision. But this is a good option if your bylaws are silent with respect to a board meeting and you have the authority to adopt a policy. You can then go ahead and adopt a board policy that allows for remote annual meetings. One caution here is that you'll want to go back to your state statute and make sure it doesn't say that remote meetings are allowed only if it's in the bylaws, because if that's the case, then a policy isn't going to give you a workaround. But this might be a good workaround for a lot of co-ops out there. And the last place that you should check if you've sort of come up short on all of these is see if your state has issued a governor's order or waivers that annual meetings can be held remotely or postponed. We're not seeing this very frequently, but there are some states that have included this in their COVID-19 orders. So what do you do if you've gone through this analysis process and you don't have a clear answer regarding whether you can hold a remote meeting, or your bylaws say that you can't hold a remote meeting? In this circumstance, we think there's a really good argument that you're not out of luck here. If postponing a meeting to a later date or doing a remote meeting is not allowed, you may still have an argument that it's nevertheless legal under the common law concepts of force majeure and impossibility of performance. These concepts apply to contracts, and arguably, under some state interpretations, articles and bylaws are a contract. They are a contract between the cooperative and its members. So the concepts of force majeure and impossibility of performance, you're probably most familiar with these concepts if you've been dealing with a hotel or venue contract for your annual meeting that needs to be delayed or canceled because you're not having the meeting at the time you intended. So those contracts probably include an express force majeure provision, which lays out what happens to the contract if certain acts of God, including a pandemic, make it impossible to perform. And those contract clauses will probably state how and when you can terminate, and that the typical consequences of terminating, such as penalty fees, don't apply in this circumstance. That's an express contract provision that we're not going to have in this circumstance of the annual meeting in your bylaws. But those contract provisions came out of a common law concept of impossibility. And that common law theory states that if it is impossible or impractical to perform the terms of the contract, performance is excused. And if you have a state order that prohibits you from gathering with the number of members that you have in one location, you've got a really good argument that performance is impossible. We have 2 points of caution on this if you need to go down this path to postpone or hold your meeting remotely. The first is that the contract theory is not clear law in many states. Not all states have adopted the position that articles and bylaws are considered a contract. The second caution is that even in those states that consider them, that aren't clear whether they're a contract, in those states, it's not clear. There isn't good legal precedent yet that the concepts of force majeure and impossibility would override articles and bylaws or other state statutory mandates. That doesn't mean that that they wouldn't come to the finding. It just hasn't been determined by courts yet in all states. And then you're in a circumstance where, like, do we want to be a test case? Maybe, maybe not. Overall, we think it's very low risk that courts or your members would really challenge a decision to postpone or hold a meeting remotely in these circumstances. But it's something you want to be aware of as a risk when you're weighing these options with your board and trying to decide how you're going to go forward. So after you've done that legal analysis, you've determined whether or not you can hold a remote meeting or postpone your meeting. It's not the end of the road yet. I think it's important to acknowledge that this is not your standard course of action. And so how you hold this meeting and how you communicate to your members is more important than ever, because you are taking steps that are different from the co-op's usual operations. The first really important consideration here, if you're holding a remote meeting, is to ensure that you're thinking about accessibility. If you make sure that your members have easy access to a remote meeting, and that could be having multiple options of how you can connect, having phone options, a video option, options to vote ahead of time electronically or by mail. The easier you make it to attend this meeting virtually will mitigate the possibility that dissident members have an argument that this was inappropriate. And that point about phone options is really important depending on your member base. If you have an older member base that wouldn't have a computer with a camera or wouldn't really be able to easily figure out how to log into Zoom, it's really important that you have a call-in option. So you know your member base, you probably know the unique challenges that they face, whether that's Wi-Fi accessibility or the like. So make sure you're thinking about that when you're thinking about how to set up your remote meeting. And there's a lot of creative solutions that we've been seeing for this. There's no one size fits all. So it really is going to depend on your member base and what is going to make this the easiest way for them still to attend if it's not in person. I think we've seen a couple of different co-ops do a drive-in method where they host the annual meeting at the headquarters building, and everyone stays in their car and listens to the typical presentations via a designated radio station and votes by ballots before the meeting. That's a really great option if after your review of your bylaws, you've determined that it says they must be held in one specific location. If everyone's there and never leaves their car, they're still there in that location. Another option, depending on the size of your cooperative, is to do a hybrid meeting where you strongly encourage the people to attend virtually, but allow people to attend in person as well if that is the only way that they can attend. and then strongly encourage them in that circumstance, or put a rule in place that, for instance, if multiple people are on one cooperative account, they need to send one representative only. So that's a good way to do it. If you have a smaller member population and you think that you can, and your state orders don't prohibit it, you can always do a larger room and in a way that encourages social distancing still. But it seems like most people these days are going the route of the virtual meeting. And there's a couple different methods that you can do for that. One way that we're seeing is people are live streaming their meeting over their Facebook page and voting separately in advance. One concern with that approach is security and ability to limit access. As far as I'm aware, there's not a method on Facebook Live for you to limit who can log in and view that live. But if your meetings are typically open to non-members, this might not be a concern for you. Obviously, you can use any of these other platforms that are popping up: Zoom, Google Meetings, Blue Jeans, any of those. The big concern in hosting a virtual meeting comes down to voting. And that is because whatever voting methods you use, you need to ensure that you can identify that the person submitting the vote is the person on the member account, that they actually have a right to vote. So mail-in ballots are a really easy way to do that. You can do electronic voting as well and have the person certify, send it to the email address that is on record, and have them certify that they are in fact that person. I've seen some people doing it through the chat feature in Zoom, which isn't great, but it's perhaps a good stopgap if you need to do it that way. So there's a lot of different options. Just be sure that you're thinking through clearly ahead of time what the risks are and what you are comfortable with as a board in handling that. On that voting subject, one thing that we are encouraging is, because you'll probably be using some joint method of ballot voting or electronic voting, is if it is your practice to allow members to bring measures to the floor at an annual meeting to vote, that should be suspended for this meeting, and you should instruct your members that any actions that will be raised to a vote should be raised in advance and included on that ballot. And that kind of brings me to my next point of transparency. It's really important that you circulate a good explanation of why you're postponing the meeting or holding it remotely, and any of these typical courses of action that you're taking, that you're modifying for this annual meeting. You'll have done a lot of thought process and analysis and discussion as a board to get to this stage. And because you are doing things differently, it's important that your members understand your rationale and thought process, so that they buy into it, so that they're with you and that they get why the co-op is doing things this way. And the more transparent you are, the less risk there's going to be that somebody's going to argue that the board was abusing their power in going against what the bylaws expressly state. And that brings me to my last point, is that if if your bylaws do not expressly allow you to hold a remote meeting and you're deciding that it's in the best interest of the cooperative to do it anyways, and that you're relying on these theories of impossibility or otherwise, think very, very carefully about what measures you're bringing up in the annual meeting. And again, this is, you know your members, you know your own culture and what's going on in the background. If your co-op has any internal drama at the point, or any decisions that you know are going to be controversial and will really, in normal times, would have brought huge contingents out to vote in person, think very carefully about if those measures need to be decided at this point in time. The one thing that's really important right now is that you don't use these unique circumstances to try and push through a measure that you think might not pass in a normal annual meeting. That's asking for trouble. It's asking for member objections. And you want to avoid any of that controversy if possible. Now, there might be some big decisions that you need to make right now because of COVID-19 that you just can't avoid. Like, for instance, if you need to make decisions about whether to renew a lease or other big matters, there are going to be some of these things that just have to be addressed at an annual meeting. If that's the case, again, it goes back to transparency. Be very transparent with your members about why this is up for a vote now, and why you need to vote in a different manner than usual because of the times. But you're most likely to get pushback that a meeting was invalid if it is seen as an attempt to push through an unpopular decision. So just think closely on that, and communicate to your members, and have a very frank and honest discussion with your board when you're trying to make decisions here. So let's see, I've got a question here. It says, what do we legally have to address, take action on at the annual meeting? That is a really good question, and it also comes down to your bylaws. Generally, the main thing that is going to have to be voted on at an annual meeting is your board of directors. That's something that can be postponed if you have if your bylaws allow you to postpone a meeting. That's the big thing that has to happen. Your bylaws are also probably going to have a list of critical decisions that must go to members for approval. And so when your board is taking any like larger actions, you should always go back and consult your bylaws to see what items require member approval. There might be contracts over a certain dollar threshold. If you're trying to issue a new series of preferred stock, that's probably in there. It varies from co-op to co-op. So that is the end of my prepared slides. I am happy to answer any additional questions that the group has and on any topics here. Okay, let's see, another question here. Is it permissible to hold the annual membership meeting in 3 or 4 separate meetings to keep the gathering size down and still count it as one meeting? That is a really good question. The key to that, I think, is going to come down to if those separate meetings also have a virtual option to them, because one of the main requirements is that all members can hear each other and can have that dialogue. And so that's my main concern with that approach, is that if you have 4 separate meetings and each of those 4 meetings has a very different conversation about the matter that's up, and it could have swayed a member in a different meeting to vote differently, that might be problematic. But I don't know if there's a clear answer on that one. Okay, here's another question. If director terms are specified, or a specified amount of time, 3 years, but the bylaws allowed the board to set the date and time of the meeting, and the new meeting date extends that 3 years, what happens? Your statute is probably going to have something to say about this, about how it's addressed. It's typical that the current board would just extend, and then if somebody needed to resign, there are procedures for the remaining directors to appoint a replacement. But if your statute and bylaws allow you to postpone, then those directors would typically just carry over, unless there's some other method. Like sometimes bylaws will state specifically that you can vote on directors by ballot, but not have an annual meeting by ballot. And so that might be something that you want to look into here. But otherwise, this standard approach is that they would carry over and continue until the next annual meeting. And there's normally a provision that says something like they continue until they're, for the length of their term, or until the replacement has been elected. Okay, we've got another question that's asking if it is possible to postpone or cancel a normally scheduled meeting until the following year. Yes, it is possible. Again, look to your statutes and your bylaws for what they say. They might say that most of them are going to say you have to hold a meeting annually, but then you get to the concept of impossibility, and that if you just can't hold the meeting, then there's nothing important that needs to be voted on. It's certainly possible to just cancel it. We're seeing a lot of people that are postponing indefinitely, and I think that's a reasonable position to take too, since we just really don't know when you're going to be able to safely hold a meeting. And in that case, just watch for what your normal notice provisions are for calling an annual meeting. Okay. I have a question here that says that the bylaws are silent on whether or not we can conduct a virtual meeting. Does that mean we can have a virtual meeting? If your bylaws are silent, you should go back to your state statute and see if they allow a virtual meeting. And in that case, you're probably good to go. If your statute is also silent, then I think it's a really safe argument that you can hold a virtual meeting, so long as there's nothing that's saying like it must be in person. If there isn't anything that's telling you how to have an annual meeting, then virtual is certainly allowed, as long as you're following the other rules and procedures for an annual meeting. Going back to that first question about the holding multiple meetings, we have one commenter who says that they held 2 identical virtual meetings to allow flexibility for people to join based on different schedules. And their bylaws actually specifically state that they can hold a series of meetings. That's something that's unique to them because they have a member base across the entire US. There's a lot of co-ops that are in that circumstance. If you've got a really large member base, or you've got a really varied geographic member base, you might have something similar in there that states that that you can hold a meeting in a series of meetings. So that's a good option to look for. And that's probably a good argument that this is a reasonable solution for a lot of other co-ops as well, if you're in a similar scenario. If you do go that route, I think it's important that you keep very good minutes of each of those meetings and make sure that they're shared with all of your members so that you can make sure that they are all informed after the fact of what happened at the various meetings. Okay. Let's see. Have a comment here that says Governor Walz in Minnesota had an executive order allowing one type of corporation in the state out of 7 different types of corporations in the state, the flexibility on holding annual meetings virtually or postponement. Has Cooperative Network approached the governor if he would be willing to issue an executive order for this type of flexibility for co-ops? And getting word that they will follow up with you separately on that question. But from my perspective, that's something that you should be considering and reach out to other co-ops and your various co-op groups to approach your leaders in your state to get a specific order. I know that Dorsey specifically worked with a couple of clients in Alaska at the very start of this to get a specific order allowing them to postpone annual meetings in the state. And so it works. It is something that works. And so if it is something that you should consider using your collective cooperative power to address on a government level if your state has not already addressed the issue. Let's see, next question here is asking if election ballots should have a name from the voting member attached to it to clearly identify the member. Yes, they should. That's one thing. If you haven't done voting by ballots before, and again, reach out to your different co-op contacts to figure out best practices that they use in voting. But you will need the ballot to identify who is voting, and you typically have them certify by signing that they are the official holder and have the right to vote that ballot. There are a lot of new electronic methods to vote as well. I don't have a lot of experience with them personally, so I can't speak to which is an easiest one or cost to them, but there are a lot of options out there to vote. We've got a question here that is asking, where do you look or find your state statute? So that's a good question. The first, if you don't know what your cooperative is organized under, it's probably stated in your, it's probably stated somewhere on your articles of incorporation, because those are what is filed with the state. So somewhere on there, it's going to identify what statute you're organized under. States have their own websites that hold all of that have all of the state statutes available for reference. And if you just Google it, you'll find it. But I recommend make sure you look at your actual state's statute because there are a lot of third-party sites that that aggregate state statutes and pull them, but they might not necessarily be the current statute that will be controlling on you. So go to the source at your state to look to what they what your statute says. All right, we have another question here that says they normally have a delegate session on resolutions to determine our public policy. Is that something that needs to take place? I think that is going to depend on whether you normally do this because your corporate governance documents say it's a requirement, or if it's just a historical practice of the co-op. If it's just a historical practice that isn't a requirement, then it's much easier for you to decide that that's something that you can postpone and continue on your current public policy for another year. If it's a requirement that's laid out in your bylaws, then it's go through a similar analysis of whether or not there's anything else in your bylaws or any other policies that would allow you to postpone that decision or have that meeting remotely. And that is all that I'm currently seeing. If there are any other questions, feel free to submit them in the Q&A box.
Well, thank you, everyone. I think we are going to wrap up then. Thank you, Morgan. That was extremely informative for our members. If any of our members listening today have further questions, please contact Cooperative Network directly, and we will work with you to get those resolved. Please make your calendars, mark your calendars for this upcoming Cooperative Network e-learning webinars. We will be having one on July 21st. Actually, two. We'll have our State of the State webinars, one for Minnesota and a separate one for Wisconsin. Join us as we will be talking with state leaders and political commentators on the issues facing our members during these turbulent times. And then again on August 5th and August 12th, in conjunction with Madison College, we're offering half-day seminars on managing and teleworking in this current environment. You can visit our website for more information and to register for those webinars. Thank you again to our sponsors, CoBank and CHS. And thank you most of all to Morgan for a wonderful presentation. Thank you for being with us today. Thank all of you for joining us. Stay healthy, be well, be safe. Thank you for supporting Cooperative Network.
Thank you.